English Senior Unknown Speed Speech of Honorable Minister of Law and Justice at the valedictory session of Platinum Jubilee Function of Income Tax Appellate Tribunal on 25th January 2016 at New Delhi. Honorable Minister for Finance, Corporate Affairs and Information and Broadcasting Sri Arun Jaitley Ji, Law Secretary Sri P.K. Malgotra, President, Vice Presidents and members of the Ladies and gentlemen, I am extremely glad to be present here at the valedictory session of the Platinum Jubilee celebration of ITAT, the tribunal which was set up in 1941 to function as an impartial quasi-judicial body to resolve the disputes between the revenue and tax-paying public is completing 75th years now. The concept of tribunals has been borrowed from the French system of the trivet administratif, which referred to a system of administrative courts that ran parallel to the civil courts. The intention behind this system was to ease the civil courts from administrative matters while laying separate standards for administrative disputes. The modern Indian Republic was born as a welfare state, and thus the burden on the government to provide a cost of welfare services to the people was immense. The quasi-judicial powers acquired by the administration led to a huge number of cases with respect to the manner in which these administrative bodies arrived at their decisions. The vast number of welfare legislations coupled with the right to judicial review was thought to burden the civil courts with more matters than they would be able to handle. Thus, various tribunals for income tax matters, railway rates, labor matters, and company courts were given statutory legitimacy to function parallel to ordinary civil courts. The concept of triad administrative is in contradiction to disease rule of law, where everybody in a state shall be subjected to some common law, and there is no need for extraordinary tribunals to deal with cases of government and its servants. To deceive, it seemed strange that when the injured individual sought protection against the administration, he had to run to an administrative body, the council, which was certainly closer to the administration than the judicial courts. In India, the adjudication of administrative disputes has been commanded by the judiciary through various cases placed before it over a period of time. As of now, we understand that a complete adoption of triad administrative is not possible in India because judicial review of tribunals orders cannot fully be removed, judicial review being an integral part of our constitution. While the matter seems to be put to rest with Supreme Court's 1997 famous decision in L. Chandrakumar case, the debate has not ended yet, and much remains to be tested in the context of working independence and efficacy of the tribunals. There have been many success stories of the tribunals, yet there have been instances of delays and favoritism as well, though the courts have consistently held that these bodies must maintain procedural safeguards while arriving at their decisions and observe principles of natural justice. Yesterday, during the inauguration of Platinum Jubilee session, when Honorable President of India was also present, I had briefly touched upon the criticism of the tribunalization of justice from some quarters. While in some quarters increasing tribunalization has been criticized as an encouragement of the judiciary's independence and contrary to the constitutional scheme of the separation of powers between judiciary and the executive. The other concern has been that though they were supposed to address the issue of delays and pendency in the existing judicial system, they seem to be bogged down with the same problems. Also, it is alleged that the tribunals lack independence and are no better than the administrative arm of the ministries. Be it like that, the tribunals are here to say the tribunals play an important role in the sphere of the judicialization of disputes. Tribunals function differently from courts from the manner of appointment to the procedure followed. The tribunals do not have to follow the uniform procedure as laid down under the Civil Procedure Code and under the Indian Evidence Act, but they have to follow the principles of natural justice. Nevertheless, they seek to achieve the same objective as that of the courts, to impart and deliver justice. Friends, within the four walls of judicial review, the tribunals carry a great responsibility of not only resolving disputes but also executing higher standards of performance, as mostly the tribunals have been reviewing or overseeing appeals from the actions of the administration. The effectiveness of the tribunals can be gauged, and in fact the very objective of setting up of the tribunals can be said to be fulfilled only when the tribunals come up to the expectations of its stakeholders, and if the litmus test is that whether the institution is maintaining consistency of it being fair and judicious, apart from rendering speedy justice, I think has passed with distinction. Working of the institution depends upon the reputation which it builds up over a period of time, and ITAT has lived up to the expectations.